Hello students, welcome to Epitome IAS. So, in this session we are going to discuss a question from UPSC General Studies paper 2, that is what is quasi judicial body, and explain with concrete examples, right. So, of course it appears to be a direct question, but we need to give a very reasoned answer, right. So, coming to the nature of this question, it is a direct question of course, but we need to explain the quasi judicial bodies with proper examples. Okay. So, coming to what is quasi judicial body, right. What is quasi judicial body? So, we can directly start the answer from the very definition itself. Okay. Quasi judicial body means it is a non judicial body, or extra judicial body, which performs or exercises the functions of judiciary. Okay. So, despite it is a non-judicial body or extra-judicial body, it has the functions of judiciary. It performs the functions of judiciary, right. What are the functions of judiciary, right? What are the functions of judiciary? Particularly, the judicial function is related to resolution of disputes. Of course, judiciary has a larger role to play. It performs the function of protection of rights, particularly Supreme Court and High Court, the fundamental rights. Okay, rest of the rights are protected by other courts of the country. Okay. So, particularly we are trying to explain the quasi judicial body in terms of resolution of disputes. This function of judiciary is performed by quasi judicial body, right. Then while the judiciary is existing already, what is the purpose to introduce the quasi judicial bodies? What is the requirement of introducing the quasi judicial bodies, right? Because the quasi judicial bodies have been introduced in India in parallel to the judiciary, despite the judiciary is existing. Okay. Because the quasi judicial bodies will be dealing with the matters having technical or administrative importance, in importance. Okay. Because certain matters require to be disposed of very quickly. Okay. They must be resolved very quickly, right, and the matters involve the subject or technical expertise. So, definitely in that course the quasi judicial body will be having the flexibility, will be having the composition in order to solve the matters having the technical or subject matter importance. Okay, right. So, for example, the quasi judicial body will not follow the procedural laws, right. What are the procedural laws? The procedural laws are nothing but those are the laws which act as the procedural means or basis for the judicial functioning. Okay. For example, if the judiciary, if you try to see the nature of laws, the laws are of two types. One is substantive laws and second one is procedural laws. Okay. Substantive means those laws which aim at the discharge of justice. Okay. Those laws which try to solve a particular problem, those laws which try to find a solution for a particular problem, those laws are called as substantive laws. Okay. Substantive laws are nothing but the laws which arrive at the justice, the laws which will find the solution, the laws which are the basis for the resolution of the dispute. What is the justice part of the issue that is dealt by substantive laws. For example, in the criminal matters, the substantive laws like BNS, Bharatiya Nyaya Sanhita. In the case of the civil side, there is a law called as the Indian Contract Act, for example. There can be any number of laws, but this is how the contractual disputes will be found a kind of a solution in the on the basis of Indian Contract Act. What is the compensation, what is the relief, okay, those are the things which are dealt by Indian Contract Act. On the other hand, BNS, Bharatiya Nyaya Sanhita. The Bharatiya Nyaya Sanhita is the way how to punish a person. I mean, what is the punishment for any given crime? That is what BNS. This is what substantive law. Coming to the procedural law. Procedural law means the way, the approach you follow to discharge the justice. Okay, the means you follow to discharge the justice is called as procedural law. For example, you have CPC on civil side, CRPC on the criminal side. CRPC presently it is Bharatiya Nagarik Suraksha Sanhita. Bharatiya Nagarik Suraksha Sanhita. It is civil procedure code. This is how there is substantive side of the law as well as procedural side of the law, right? So in this way, the justice is rendered by the judiciary. Judiciary will be taking into account of both substantive law as well as procedural law. But when it comes to the quasi-judicial body, it will be taking the help of the substantive law. It will be functioning on the basis of substantive law. It will not be following the procedural law. Rather, in the place of the procedural law, the quasi-judicial body will be taking the advantage of the flexibility. Flexibility means you are not going to adjudicate the proceedings, adjudicating the disputes on the basis of the advocate, on the basis of the formality. What does that means? So flexibility is offered by informality. Flexibility is offered by client centricity, where the client can come and argue the case on her own or his own. Okay. On the other hand, there will be informality, there is a flexibility. So what kind of procedure that must be adapted by the given quasi-judicial body in order to resolve the dispute, that is what called as flexibility, right. So this is what the understanding or advantage of the quasi-judicial body. Because of this flexibility, what will happen? Because of the procedural flexibility, because of the freedom from following this kind of procedural laws, what is the advantage? The advantage here is they are going to resolve the dispute very quickly, and they are not going to encounter any kind of technical hurdles in the course of the resolution of the dispute, and moreover the process can be better understandable by the client. That means the client can get the justice instantaneously sometimes, and the client can engage with the arguments. He can also give his own arguments, and the court, I mean the fee that is charged by the quasi-judicial bodies is also very much lesser. Okay, this is how we can understand what is quasi-judicial body. I hope you understood. Quasi-judicial body has these kind of characteristic features, like for example, it is established by a statute. Okay. Number 2, it enjoys procedural flexibility. Number 3, it is client centric. It is headed by experts. Usually the tribunals have wider composition, having the judicial members and technical members, right. Next, usually they deal with non-criminal matters. Okay. Moreover, despite they are established by the statute, that means their functions are confined to the scope determined by the statute. Okay, the scope is confined to the scope determined by the statute, right. Then after understanding this, of course, there is a Tribunal Reforms Act, there is a Supreme Court judgments regarding the functioning of the tribunals. Of course, it is out of the scope, okay, but we need to give some examples for the quasi-judicial bodies. We need to give some examples because the question itself explained with concrete examples, okay, right. So how do we explain this? What kind of examples we can find? Examples for quasi-judicial bodies. Examples for quasi-judicial bodies. If you try to see the examples, number 1, tribunals. So the tribunals are established according to the Article 323A and 323B. Okay. So these are administrative tribunals. These are tribunals for other matters. So here only Parliament can enact. Only Parliament can enact a law to provide administrative tribunal for states as well as center. Okay. But in the case of Article 323B, administrative tribunals can be established for any other matter other than administrative matter. Okay. So in this matter, the state government can enact its own laws to establish the tribunals, and Union Parliament can also establish its own laws to enact establish the tribunals. Right. For example, land dispute, trade disputes, the states can establish for their own matters. And those matters which fall under the Union government, the central government can be enacting the laws and establish the tribunals. Similarly, we can see other examples for the tribunals, like Speaker. He is also quasi-judicial body because in the capacity of Anti-Defection Act. Okay. Because he will decide the disqualification of the defected MLAs or MPs. In the case of Lok Sabha, Speaker. In the case of Rajya Sabha, it is the chairperson. In the case of State Legislative Assembly, it is a Speaker. In the case of State Legislative Council, it is a chairperson, like that. And there is the Attorney General. Attorney General, he will be acting like a tribunal or quasi-judicial body in the matters of Contempt of the Court Act. Contempt of the Courts Act, where his consent is required in order to prosecute any person for the allegations of the indulgence in the contempt of the court. Okay, right. Similarly, we can also find other institutions. Okay, for example, we can see we have seen just now. We have seen the examples of revenue courts at district level to resolve the revenue matters. Similarly, citizenship related tribunals which deal with the disputes related to the disputes of the disputes involving the citizenship. Okay. Similarly, we can also see arbitration tribunals. Arbitration tribunals which are established according to Arbitration and Conciliation Act, Arbitration and Conciliation Act. So they also enjoy the powers of the tribunals. Okay, right. We can also see CAT, Central Administrative Tribunal, SAT, State Administrative Tribunal. Okay, right. Even the district collector in certain matters, commissioner of police in certain matters, they will also exercise quasi-judicial powers. For example, district collector or commissioner of police, they can also give preventive detention orders, PD orders. So they are giving detention orders, means they are giving the permission to keep a person under the imprisonment, okay, or detain the person for some time. So that is also something like quasi-judicial function. So that's why quasi means partially. Judicial means judicial function. Okay, right. So I hope I have given wide-ranging examples. Okay, so now we need to conclude. Okay, but we need to understand why they have been established. What is the significance of their establishment? The significance is that after LPG, government has adapted an approach called as ease of doing business. Ease of doing business. Minimum government, maximum governance. Okay, for the sake of justice, people shall not be waiting for longer times. People shall be getting the justice in the instantaneous and quickest manner possible. This will improve the business environment in the country, so that the growth and development is possible. So one of the major hurdles for the ease of doing business is the justice dispensation. Okay, because two reasons I told you. One is the problems within the judiciary, and number two, the problems with respect to the increasing litigation in the society. So that is possible to be settled easily by means of quasi-judicial bodies, right. So that's why there is a kind of a proliferation of tribunals in the country after LPG. That's why it is called as tribunalization of justice. Tribunalization of justice, and it is potential to violate separation of powers. Separation of powers. The principle of separation of powers. Right. That's why Supreme Court in Madras Bar Association case held that there must be an independent functioning of the tribunals away from the executive, and the tribunals must be placed under independent body like All India Tribunals Commission, like that kind of body must be established. So in order to separate the tribunals from the executive influence. Okay, right. So that's how you are able to see certain important aspects, why they are very much contextually important. Okay, so there is a kind of proliferation of tribunals due to the demands for the improving the ease of doing business, and also there is also a demand for the expertise in the dispute resolution mechanism, right. So for that reason also these are very much significant, but however the concern is they violate the separation of powers. Okay, the principle of separation of powers, because executive in a way they will be having more and more influence. But Supreme Court judgments, if you try to see, there are two important landmark judgments. One is Chandrakumar versus Union of India, and number two is Madras Bar Association case. These are very much important. In the Chandrakumar case, Supreme Court said that the tribunal's final orders can be challenged in the division bench of the High Court. That is number one. That means they are subjected to judicial review conducted by the High Court. Then they are not necessarily to be challenged in the Supreme Court directly. That is number one. Number two, in the Madras Bar Association case, just now I told you, they must be given autonomy and independence and from the executive. So this is how we can understand this particular question. Okay, right. So we can summarize the answer in the form of conclusion. Thus, the tribunals are the mechanisms to resolve the disputes in the most flexible, client-centric, and they offer expertise to resolve the disputes in the most possible way. They can resolve these disputes in the most efficient manner. Okay, but however there are concerns like they violate the principle of separation of powers, okay, and also they may give a kind of imbalance in the the distribution of powers given under the constitution, that it may give more predominance for the executive over the other bodies of the state. So that is how you can write the conclusion. Okay, conclusion is something which reflect the overall answer. Okay, whatever you have discussed in the introduction, you mentioned in the introduction and discussed in the body, they must be reflected in the conclusion. Okay, otherwise sometimes if the question is expecting some kind of suggestion from you, definitely it is open for the reforms, it is open for the further improvements that particular policy or that particular issue, then you can write the way forward. Okay, hope I think you have followed the discussion quite closely. Try to understand the subject in the holistic manner so that you can write the better answers according to the demand of the question. Thank you.